Rekha, Ramjit, thank you so much for being here with us this morning.
And as usual, it is my pleasure.
It is great to see you here. I'm looking at the just concluded, was it June 1st? The just concluded meeting of the Law Association.
Yes.
This, of course, deals with the chaos or the confusion or the blown out of proportion. It all depends on how you look at it. The situation in the judiciary. And they called a meeting to see how many attorneys have confidence in the Chief Justice and how many are going to vote that there is no confidence. It was a no confidence motion. It came out at 285 to 150.
That's right.
It was the vote. So you had a lot of attorneys with dissenting views. All right, good. What was interesting, however, is post that meeting, the comments made by a number of people that, of course, got the ink and they got the front pages, not the least of them being the leader of the opposition. Of course, she is an attorney. Of course, she's entitled to her opinion, as any attorney is. However, you said you had a problem with some of the comments coming from her, Attorney Rekha Ramjit, because you said she was... Ms. Ramjit, also the head of the ILP, just that you know. You said she was not present at this meeting, so how could she... Please go ahead.
Unless she was, of course, hidden somewhere. I got there pretty early, and the halls were filled. The hall was filled, upstairs and downstairs. And I'm sure if the opposition leader walked in, there would have been some amount of parade surrounding that. And I am certain that had she been present, she would have made a comment. Her having made several comments prior to that meeting, she would have wanted to have her thoughts heard on the matter. Of course, it was a closed meeting in that the very first things that were decided is that the press would not be allowed in. And I want to say, when that call was made, I agreed with that call primarily because I feel a lot of times the press does not get it right. And this was one of those situations where you did not want the wrong information or manipulation of the information to be put out there in public. So for that purpose, I absolutely agree that the press should not have been there for that private meeting, and the ballot was going to be secret. So I never saw her there. I was seated at the front, so I would have seen her. I didn't see her. And more importantly, at the press conferences outside, because the media was waiting outside, she would have been approached, and she was not approached. The persons that spoke was Mr. Ramdeen, Senior Counsel Daly, and my good friend Keith Scotland. I saw all of that, but I never saw. So she spoke in the parliament. Now, this is an issue that affects the entire country, and unfortunately, her comments, her not being present, everybody is entitled to make a comment. As senior counsel, she's certainly entitled to make a comment. But more importantly, if she felt so strongly about it, why did you not attend the meeting and have your thoughts heard and persuade or dissuade the group that would, because that was the intent. There would be a debate. Take part in the debate. You waited until the vote was counted, and then you made a comment in the corridors of the parliament, which makes it political. And it is unfortunate that in this country, a matter that affects what ought to be the most independent of institutions in the country was being discussed in the corridors of the political powers. And unfortunately in this country, and I say this without apology, in this country, when the politicians get involved in making their comments, it immediately degenerates into a situation of race. So that first we have the political influence, and because there's so much politics, it has degenerated into race. So if you look at the social media, it has degenerated into race again. Once again, we have something that is important to this entire country, and it's degenerated into race. I got there early because I wanted to understand what was happening, because when you're out there and you're reading what's in the media, you don't have a clear understanding of what is happening. At that particular meeting, several documents were presented, several arguments were presented by persons 2 and 4, the particular motions being debated, and then I can make a reasoned decision. Because as an attorney at law who practices in all the fields, but mainly in the criminal arena, my clients are affected. And I was not only representing my personal view, but I was representing the view of the people I represent on a daily basis, because they are affected by the actions of the CJ, the committee, the magistracy, and the DPP. They're affected by those actions.
Just so that I'm very clear, you said that the opposition leader was not there, but even to leave that aside, just so folks are very clear, she had the right to make a representation, as you concurred with. The fact of the matter is, you were not in objection to what she had to say, but where it was said. Am I correct on that?
Well, actually, where it was said, yes, and she has the right to make a comment with regard to whether she feels the CJ should step down or not. Her particular position requires that she act with a certain amount of reasoned behavior, because she's in a position to influence a lot of people, and she's in a position where she knows, and this country knows, that when she speaks, there are people who don't understand the issues but will follow exactly what she says, right? So my point is this: why you, as senior counsel, would want to take a matter that's supposed to be treated with independence and objectivity and land it in the middle of the political arena?
There are many, including the former Law Association President Reginald Amore, who said that this is a storm in a teacup, comparatively speaking. He said there are many others who proffer that while an error may have occurred here, many people are using this to advance their own agendas, while at the same time unwittingly undermining the institutional pillar of democratic societies, which is the judiciary.
I want to disagree with Senior Counsel Mr. Amore. I have great respect for him, but in this particular situation, I am of the opinion that the judiciary has suffered a real beating, and there's a lack of trust and confidence. If he recalls the issue of the elevation of not only Marcia Caesar, but also another magistrate to the bench, caused
Judge
concern.
Williams,
Yes, caused concern for a lot of people. Now that we find that something was wrong or flawed with the process, it is not a storm in a teacup. Because I want to say this, that in this country, unlike other countries, there are non-bailable offenses. And when there are non-bailable offenses, what we must remember, that those persons who get charged with that, they are innocent until proven guilty. And if you are in a position to fast track that preliminary inquiry, as the case may be, then you must do so. It is unfair and inhumane to have somebody sitting in prison without the option of bail for a period of 7 or more years, and then come back and say to them, we may have to start your matter de novo. De novo means we start it all over again, right? The stress and the trauma is not right, because that person is innocent until proven guilty, no matter how much you, as the prosecutor, believe that they are guilty. So it is not a storm in a teacup, because you are dealing with people's liberty and freedom. And that is a right protected under the Constitution. You take it away, you must take it away with due process of law.
Let me qualify, unless I be misunderstood or I misquote what he was referring to, specifically the question of the removal of the Chief Justice. He said what has happened here does not reach the threshold for the removal.
Well, I don't know that,
for the Chief Justice to be resigned.
I don't know that the meeting was for the removal of the Chief Justice. I heard him to say that it is it's borderline impeachment. What the meeting was about was a vote of no confidence. A vote of no confidence says that the CJ may then take whatever action he deems appropriate in response to that vote of no confidence. What is the threshold, and how much are we going to put up with? We are too... In this country, the CJ is a leader. As much as the Prime Minister is a leader, as much as a labor union leader is a leader, we are too accommodating of when our leaders make errors that affect the lives of people in Trinidad and Tobago. And we have to stop that. And you must remember that the judiciary is the last bastion of integrity and protection of people's rights. And if we are to accommodate that, then we have a serious problem. Now, it is unfortunate that this started with an agitation, for want of a better word, by Senator Ramdeen, Attorney at Law Ramdeen, because he himself has several unanswered questions about his own reputation. But when I have a difficulty with Mr. Ramjit being a senator in this country. I have a difficulty with him heading it, as it were. But I have to go beyond that, and I have to look at what are the merits and the demerits of this particular issue and deal with that. I must forget that. But unfortunately, those people who hold the power in this country, and in particular the opposition leader, who ought to know better, took the opportunity to politicize something that ought to be very independent and objective.
Are you optimistic about some changes coming out of the vote of no confidence in the Chief Justice? Are you optimistic about some changes being initiated by him to meet halfway with this vote of no confidence?
Well, you see, the Chief Justice has said in no uncertain terms that he's not about to resign. He can be removed to a procedure stated in the Constitution, and that involves the President. So that has to be left to be seen, and I can't proffer an opinion on that because it's really, are we it's like a contest. You know, who's the big? It's a macho contest.
My reading of this says that
I don't want to use the word I really want to use.
I know.
I can't use the word I really want to use, but it is a contest of who's bigger, who's have more power.
To be impeached, I think you're looking at mental incompetence. Yeah. I think the Constitution calls for specifically.
Of course, and it is unfortunate that senior counsel, Mr. Armour, would go down that road, because it's not about that. We are not saying that he's mentally incompetent. We are saying that his actions has caused such an upheaval in the justice system that it has affected the trust and confidence of John public. And the justice system is not for the 450 lawyers who voted. It's not for the CJ. It's not for the JLSC. It's not for the politicians. It's for John public.
23 minutes after 11 o'clock. The passion you hear comes from criminal attorney, defense attorney Rekha Ramjit, and the ILP leader. We are here this morning. I thank you very much for dealing with that situation that just came on the agenda. I want to do a quick turnaround 180 on this one and get into the area of what we said we were getting together this week for that is equally important. This whole question of adverse possessor. Now, let's see if we can lay this on for a moment.
Before you go on,
I'm sorry,
I don't want to be described as an expert in that area. What I want to say is I have delved into the law, and if people recall the 2015 elections, I would have dealt with that particular thing a great deal on the platform. But more importantly, I have represented citizens of this country in that particular arena. So I wouldn't want to call myself an expert. I want to say that I have some experience in dealing with that.
Thank you for the correction, putting it in perspective there. All right. There's been, many argue, a land grab in Trinidad and Tobago, much of it encouraged by politicians who mislead the flock, they say, or seek to bring about their version of financial equity, or we time now wealth distribution. Some people also illegally occupied property solely because they wanted a place to live, and then they lay claim to the property under the statute adverse possessor. Explain to us what that is, please.
Okay. First of all, an adverse possessor is somebody who goes onto land belonging to someone else and occupies that land for a specific period of time. If it is land belonging to a private owner, then that period will be 16 years. And if it is land belonging to the state, it will be 30 years. If, however, you were renting land and then you stop paying the rent, it will be 17 years, 1 year being for tenant at will, and then the 16 years. So you must have occupied it for either 16 or 17 years or 30 years in the case of the state. The second requirement is that you must show by way of your conduct and everything that you do that you intended to possess that land to the exclusion of the true owner. So the acts that you do, how you deal with the land, is what determines whether you have the intention to possess. The other thing that you must do is you must show that that possession was continuous over that period of time. And there is something in the law that says that if, for example, your grandfather occupied the land and then you occupied it, that occupation can be transferred onto you to make up the 30 years or 16 years. So the occupation must be continuous. You cannot have occupied it for 5 years, gone away for 10 years, come back and occupied it again, and then claim adverse possession. That is not continuous. And the fourth thing that is required is the owner must not have made any moves to remove you from the land. And in our jurisdiction, that has been interpreted by case law, by judges, to mean that they must take you to court. They mustn't just come and tell you, look, this is my land, get off. They must take you to court. There must be an action in court.
So if the state advised you that you were there illegally a number of times, but they did not take you to court, that is not sufficient.
That is not sufficient. And there's another aspect that people are not really aware of. And I think people in Trinidad and Tobago, and I'm speaking particularly to those persons who would have occupied the land because they needed somewhere to live and they couldn't afford the rent, or there just wasn't anything available for them to live in. I'm not speaking to those persons who occupy 30 acres of land for business purposes at the behest of a political party.
Oh, we get in that. We get in that.
Yes, I'm not speaking to them. I'm speaking to the people who truly need a place to live, and where the country's government, at whatever time period, were not able to provide any assistance, right? Because it is the duty of the government of any country to provide shelter, etc., for its citizens, in my humble opinion, right? So there have been situations where, for example, I'm in occupation of the land for 20 years. And then somebody comes and says, let's say the LSA, for example, come and says, well, we're going to regularize your title, but you're going to have to pay us A, B, and C. And you sign an agreement to do that. Yes? Now, that is normally a recognition that the government owned the land. Right? Let's say you've been in there in excess of 30 years. But it does not affect your right to the land. You would have established your adverse possessory title. You would have established that in spite of signing an agreement to purchase or to rent or whatever, once you have occupied it for the period of time required by law. Because for the normal person, and let me say that most people, Trinidadians and all over the world, generally are good people. And they want to do what is right. And so if the government comes to them and say, after they've been on the land for 40 years, and says, we establish an agency called LSC, and we're going to regularize your title, and you sign an agreement to do that you have now recognized them as the owners and you've lost your possessory title. No, that's not so. You can agree to purchase, you can agree to rent, because you want to regularize your title. Does not mean that it affects the fact that you have established the possessory title, especially or because you would have been there for the number of years required. If you have not been there for the number of years required, then of course you have recognized their right before you have become an adverse possessor.
I want to go into one of the areas that I believe you covered or alluded to the last time you were here. The question of land, that is the what initially started or brought about this adverse possessor law is in the times before, if land was there in
medieval times,
yes. Land was there, it was unused, but someone came on and used that land and was productive on it, providing for people. That, you say, is what brought about this legislation. Because
now our law is based on English law,
right?
And the concept is hundreds and hundreds of acres would lie fallow because it was owned by dukes and earls and princes, etc. And if you made productive use of the land, right, today, and you treated it as your own, because land is such a valuable asset, it should not be allowed to remain fallow. It should be put to good use to the benefit of the country.
Right.
And that is the genesis of adverse possession. It is now not as people now want to say, well, the boldface, they come and take my land. Right, this is law that has been developed since the medieval ages.
And the reason the reason that I went back there, Attorney Rekha Ramjit, who is my guest here this morning, happy to have you here. The reason I went back there, because a lot of people are occupying agricultural land, and they never moved in to do anything with the land, save for occupying it for their premises. They never moved to develop it or anything like that. Is there any consideration in?
Unfortunately, the law doesn't recognize that genesis anymore, right? I'm telling you what the history where it started.
Gotcha.
What the only requirements are, as I said before, you must have occupied it and used. But you would find that people who've occupied a piece of land, they would have marked off a piece of land, they would have planted whatever, whether it's decorative plants or they've used it for kitchen garden or whatever, or maybe a small business, but they would have done so over
Any
a period of time.
specifications in this adverse possessor statute as to how much land a person is allowed to have?
No, the amount is determined by what you occupy. Occupation. It is not determined right. So that, and I want to get back here. I want to get back because, seriously, there ought to be a different treatment for people who occupy land because they needed to. And that can be easily determined, as opposed to people who occupied land because they were persuaded to do so, or maybe not persuaded to do so, but take advantage of a particular situation in the country. I'm choosing my words very, very carefully, but you go occupy land in Central that is valuable agricultural land, etc., and put down a business and then claim adverse possession at the behest of a particular political party. So I'm not dealing with that at all. I am dealing with persons who have essentially occupied the land to build a small house and to have some sort of income arising out of that land.
What about those who have occupied land now claiming that right to it under the adverse possession statute, but in the interim they occupied more than just enough for a house and they went on to sublet, assign, or rent this land?
Well, you cannot sublet and assign or rent something that is not yours. In the first instance.
In the first instance,
in the second instance, yes. What we have had over the years is that you may have somebody occupy, let us say, 2 lots of land for 30 or 40 years, and then a child of that family may have built a house on close to or on that same plot of land. It's a difficult situation, but if it is that the person who gave the permission, father gave the permission to son, if father would have established his adverse possession prior to giving that permission, then that's fine, because he would have established possession of that particular area. He cannot be occupying this area and then tell his son, go occupy that area. That is not possession. That is not permission, or he cannot give permission to occupy something that is not his own. Therefore, before you can give permission for somebody to occupy, you must have established for yourself adverse possession.
So,
for that.
Just that I'm very clear here, and we all very clear. So you occupied a parcel of land, and you do it in state land. It's 30 years you're supposed to be there.
Yes.
And if it's private ownership,
16, maybe 17 if there was
17.
a rented.
So yes. if there's an area here that you've built your house on and you stay there for, let's stay with the state for a moment, 30 years, fine. But your child or relative come and you tell them to go on the adjacent land.
No, you
but,
don't
but,
have...
But you never owned it in the first place.
No, but you can't. Therefore, that person is a squatter. That person is a squatter unless they have accomplished or completed the 30 years. So you cannot give permission to somebody to rent or occupy or own something that is not your own.
Anyone on state land right now who has not been there for 30 years, they are in the category of a squatter.
Yes, they are.
Explain.
Very definitely so.
And what was it? The comfort leases?
No, it's a letter of comfort that is a waste of paper, a waste of tree, destroying the environment for nothing to write a letter of comfort.
I want you to explain that because a lot of our listeners heard about this letter of comfort, and I just want you to detail that for me.
It is a ruse by the politicians to give persons whose vote they want to capture a piece of paper that says, I am not going to remove you. But look closely at it. I'm not going to remove you. But if I give you that paper today and you were to,
accept it.
Well, not only accept it, but if you were to unfortunately die the next day, then I can remove your husband, your wife, your children, everybody else. So it is personal in nature. That's the first thing. It does not give you the right to anything. All it says that I, People's Partnership, or PNM, not going to remove you, Rennie Bishop, from this piece of land. That's all it says. You cannot take that to a bank, a credit union, or any financial institution to assist you with the development of your property. So it is a waste of paper. It is just saying at election time to whole groups of people, well, look, we're going to do something for you. But I am telling you that there are people out there with comfort letters 20 years old and 15 years old. And then, of course, there was the Regularization Act and the Land Settlement Agency. What that sought to do was say, okay, this is an area that we are going to regularize people in. So let me just pick down the road there, right? People have occupied it as squatters. We are going to regularize them in that area. It has been designated, and the Act itself lists out all those places in Trinidad and Tobago. And what we are supposed to do first is put down the infrastructure, give you a 30-year lease, and then a 199-year lease. But you are supposed to pay us certain amounts for the structural development and for the land itself, right? That has fallen apart. I mean, talk to LSA. LSA was on in the media recently.
Yes, they went before the Joint Select Committee.
Right. They were in the media recently, and that has hardly been done. And then there were areas that were not designated settlement areas where people were squatting, and they had promised those people that they will be relocated to the land settlement areas. That has not been done. So it is 1998. 1998, that act was passed under Basti Pandey regime, yes? And successive governments have done nothing about it. 2 or 3 leases handed out over a period of time. People have their application for 20 or 30 years. They have far surpassed the requirement for claiming it under adverse possession, and nothing has been done. In the last general election, and I'm not being political here, you can check the records, this is a statement of fact. Kamala Possessor stood up in Diego Martin and said that I will give 60,000 lots between Port of Spain and Toco. A carte blanche statement with no reference to whether or not the person where she's going to get 60,000 people, whether those people are indeed entitled to the lot, where it is going to be, and what is going to happen.
9 out of 10 times you fact check half the things that's said on the hustings and you realize it's really going nowhere. I do want to take this into some area because our time is beginning to collapse on me, but I must get into the question of companies sitting on land and claiming adverse possessor rights. Speak to me about that.
That is so wrong. That is so wrong, and it is wrong because let's go back to why people squat. Let's really deal with that. Why people squat? People squat because essentially they have no place to live. Right? Either their family holding cannot accommodate them anymore. They cannot afford to buy land. They are not being successful when they make their applications to agency, and they must find somewhere to live. This is a basic need that they are dealing with. I personally have no difficulty with dealing with that situation. But when you have companies who make in millions of dollars, and when you have companies who can contribute to political parties in millions of dollars, why should they be allowed to get any land free? Because that is essentially what it is, by claiming adverse possession. In the first place, a company's building is not a small building. It's not a shack made out of cardboard or plywood, as the case may be. It is a huge building costing millions of dollars. Right? And a company does due diligence to find out who the owner is. A company is not just going to go there and put down buildings costing millions of dollars without doing all the information.
Cannot claim ignorance. You knew full well what it was.
Right? And why is it a company is going to be allowed to occupy with the intention of possessing to the exclusion of the true owners for profit? That is the issue.
Does the statute guard against that, however?
It doesn't. My recollection is it doesn't.
It
does says. And remember,
so companies
all
who
over
want to
the
push
world,
the envelope can do that.
Well, they do that with the encourage of the political parties of whoever is sitting in government. And all over the world, a company is a legal person, right? Now, you can test it by saying, can a company who is a legal person form the intention to occupy to the exclusion of the whole world? You can do that, but that is on tested grounds. So this country has, I mean, if you have chosen to go and occupy lands in Central, 30, 40 acres or whatever,
as a couple have.
Well, that's why I keep referring to it, because I know that they've done that. Then I think, in all fairness to the country, to the citizens of the country, that they should be made to pay the market value of the land.
That's exactly the point, yes.
Yeah, pay the market value of the land, because one has to still be humane in whatever the circumstances. And one must therefore say, okay, you're a company, you have a choice. You can break down your stuff and move, or you can pay us.
At market rates.
At market rates.
And that's the important thing, because one of the things that has happened is that some companies would go on a little piece of land, probably eventually get permission to stay there, but in the meantime, they expanded a lot of things around them, and then they claim that land under the adverse possessor statute. And if you look at what the value of that property is now, and you don't charge at those rates, then you're shortchanging the exchequer.
I believe that they should be made to ask leave or thing. We have brilliant lawyers in this country, you know. We have really brilliant lawyers in this country. Anand Ram Logan, Martin Daly, a whole host of them who can deal with this situation. Except, of course, that a lot of our brilliant lawyers are so politically inclined that where it does not suit the purpose of their political party, it will not be done. And again, I say that without apology.
You usually say things without apology. Just to be very clear. Attorney Rekha Ramjit, who is also the leader of the ILP. Again, it is always a pleasure having you here. We have made categorically clear this morning the criteria for adverse possession.
Right.
Possessor status. We've made very clear what that involves here. We've also made it very clear that the statute does not discriminate against businesses making that claim, but that is something that the citizenry must make a move to correct.
Now, there was a situation in Sangre Grande recently where persons' houses were pushed down.
Yes.
Right. And of course, most of perhaps all of them were squatters. Yes?
Yes, by their own admission.
Or adverse possessors. Right. Now, if you're a squatter, the landowner is entitled to come and remove your building. The humane thing to do is to give you some notice. But in that particular circumstance, I wonder if it is the government took the time out to find out which of those, if not all of them, had acquired possessory title before destroying their lives. I wonder if that has been done. And that is an exercise that needs to be done.
But that was the agency. Was that government that took that decision? I mean, the decision to send in the bulldozers, was that a government decision?
I thought it was. It wasn't.
No, I think my reading of it was that it was an agency.
Well, the agency. Let me just say the agency,
yes.
And the agency being an agency of the state.
Yes.
Yes. So in the final, nothing in this country happens by an agency without getting a directive from the politicians.
I just thought I would get the attribution right.
Let's not pretend that these things happen.
No, it does not happen in a vacuum. We understand that very clearly. Everything is linked to something, and there is a hierarchical structure.
You know what I would like the citizens of this country to do? Not to be taken in by politicians when they come around election time and tell you, look, we are going to make sure all of you. It happened to a group of people in the St. Augustine area. Attorneys from a particular political party went and made 101 promises. They never saw them after that, and that's going to be. But we, as a people, we are good people at heart, and we are trusting people at heart, and we really want things to be right.
Tell the truth. At times we are gullible.
Yes, we are gullible. What can I say? But I'm hoping with all that is happening that we are not so gullible in the near future.
I thank you so much, Attorney Rekha Ramjit, for taking the time to be with us. As always, reminding our listeners that this interview, like all the interviews on Brunch, is going to be available by tomorrow afternoon up on YouTube. You can go, you can pull it down, and you can get the fire and the passion exhibited by my guests, and the accuracy too. Thank you so very much.
And as usual, it was my pleasure.
You have yourself a wonderful day. Thank you so very much.